Welcome to Free Speech Unmuted. I'm your co-host, Eugene Volokh of the Hoover Institution at Stanford, and your other co-host, Jade Bambauer, is on with us, as always, from the University of Florida Law School. Um, uh, it's First of all, Happy New Year to everybody, and hope it'll be a good 2026. I'm sure it'll be an interesting 2026. Things have certainly not lacked in interest over the last year. This is our 2025 Free Speech Year in Review episode. Now, we could have had a very long episode indeed. There's been a lot happening. But we're going to hit what we think are the highlights. Apologies if we've omitted your favorite item. We probably covered it in a separate episode earlier this year. But we're basically going to be talking about three matters related to the Supreme Court, two Supreme Court decisions, and one pending Supreme Court case that was argued last year. And we're going to be talking about three things involving the Trump administration, and then one more thing involving employees in speech. We'll give you more details on that as it comes around. So we've identified 7 items that we thought particularly telling. Again, we had to exclude quite a few. So we're going to begin with the Supreme Court cases because that's the way we lawyers do things. Sometimes the most important action is very far outside the Supreme Court, quite possibly this year. But we'll begin with the Supreme Court cases, and I'm going to start with the first of the cases, which was decided basically a year ago, but it feels like 10. Things move fast these days, and that's the TikTok case. So recall that Congress passed a law that basically required the TikTok social media platform to be basically divested from its current owners who have connections to China. And the sense is that they are under the influence of the Chinese government because certain aspects of the governance structure are within China and within Chinese control. So basically, the law is called a TikTok ban because it really is a ban on the operation of TikTok by its current owners. Still, of course, we're still talking, after some quite possibly not entirely legal extensions allowed by the Trump administration, we're still talking about whether TikTok is going to be divested. But the law essentially mandated this divestment. So TikTok challenged it, and the challenge began in the D.C. Circuit, where a 3-judge panel with a respected Reagan appointee, Judge Douglas Ginsburg, a respected Clinton appointee, Obama appointee, Judge Sri Srinivasan, and a respected Trump appointee, Judge Naomi Rao, considered the case and unanimously upheld the law over a First Amendment challenge. That foreshadowed, I think, in some respects, the Supreme Court decision, which also unanimously upheld the law, although on a subtly different grounds. But yeah, once you have this 3-judge panel that basically had people from both the right and the left upholding the law unanimously, it became hard to imagine that there'd be 5 justices who disagree with all 3. So the rationale that the panel gave was that, first of all, TikTok was, at least the panel majority focused on this, that TikTok was because it was possibly under the influence of the Chinese government, it enabled Chinese government to spy on American user and to monitor very closely how users use the platform, what it is they see, and maybe gather information that could be used for blackmail purposes or for other purposes. So that was one of the rationale. One might think of it as a content neutral rationale because it's not about the content of TikTok, rather it's about the harvesting of information about TikTok users and possible access to it by the Chinese intelligence agency. But there's also a content-based rationale, which is that the Chinese government would have the power indirectly, but still substantially, to influence what is shown on TikTok. and might, as a result, block certain kinds of things that it saw as inconsistent with Chinese government policy. And the panel majority concluded that that too was an adequate basis for the law, even though that's a content-based rationale. And the opinion essentially reasoned that, look, the U.S. government can't impose viewpoint-based controls on American social media platforms. Surely foreign governments wouldn't have the power to do that, and the U.S. government could take steps to prevent foreign governments from being able to do that. When it went up to the Supreme Court's opinion focused just on the content neutral rationale. It said, look, this essentially is a law that is aimed at preventing the Chinese government from having this power to spy at Americans. That is perfectly permissible, even though it does indeed potentially substantially burden the communications of Americans if TikTok is shut down. They did not focus on the content-based rationale. And they recognized that that was part of the rationale for the government's actions, but they said, look, the evidence suggests that the law would have been enacted even if the only rationale were the content neutral one. Justice Gorsuch specifically had a concurrence that specifically renounced the content-based rationale, said that rationale is impermissible, that the U.S. government can't try to prevent certain kinds of editorial judgments by platforms, even if those judgments are influenced by foreign governments. The rest of the court did not really focus on that issue, though, and instead just said the content neutral rationale is adequate. So that's where we stand. What can we take out of that? I think one big picture point is when it comes to speech and foreigners, the First Amendment rules are somewhat different. They're not completely different, but they're considerably different. There are various cases involving speech by, as or influenced by, speech on behalf of, and perhaps speech to foreigners, foreign governments, foreign organizations, foreign individuals, which approach things quite differently than would be the case for Americans. Just to give one example, the Supreme Court summarily affirmed some years ago a district court decision that upheld federal law banning non-citizens who are also not permanent residents, but who are lawfully in America from spending any money related to federal elections. Of course, Americans have a First Amendment right to spend that money, but the court essentially said, well, that's different. And there are other examples as well. That's not a general national security exception to the First Amendment. We know from cases like the Pentagon Papers case that when Americans are talking to other Americans, even about things having to do with foreign policy and with military matters and maybe national secrets, there is a very broad protection, even if that undermines potentially national security. But it's different. We see in cases like this, we just don't know how different, but it is different when it's speech by, to, or with foreign governments. So that's my summary of TikTok. Jane, well, what do you think about it?
Well, I'm curious whether you agree as a matter of description or a matter of doctrine with the court's decision to say, look, one of the rationales was content neutral, and we're only going to analyze that one. So first of all, the way you summarized it was that there was a presumption that the law would have been passed just on the basis of foreign government collection of data alone. I have my doubts, at least when my recollection from the era when Congress sort of hastily passed the law was that they were really worried about the algorithm and the kind of mind control sort of aspects of TikTok and the sort of effect on voters here and that sort of thing. So I guess, are you nervous at all about this case setting a precedent that the Supreme Court can just assume that all sort of rationales given by the DOJ should be assumed appropriate? Maybe that's not quite what they did, but are you worried at all about the way that the court made the decision?
Yeah, I think that's something that maybe cause for some unease. I don't think it's
Yeah.
clearly wrong. There is a long-standing principle in First Amendment law and other areas of the law as well that even if there's potentially an impermissible basis for the government's actions, the question then becomes, would they have done the same thing without that basis? So a classic example, which the court cited, is in public employment. Let's say somebody is fired, and we know that part of the reason was that the government didn't like his speech.
Hmm. Hmm.
But he also was
Didn't
caught,
do his job well, and
pardon?
but he also didn't do the job that
Didn't do the
well,
job
and
well. He was
right,
caught with his hands in the petty cash drawer.
right.
Um, the court wouldn't say, "Oh, well, you have to reinstate the person, even though he's
Yeah,
committed
right.
crimes, let's
Yeah,
say, or
yeah.
been incompetent, or even you have to pay damages to him for his lost job if he would have lost his job in any case, but for his speech." So there is precedent for that. You're quite right that in this kind of situation, easy for the court to say, "Oh, it would have been enacted even without this." Hard to know for sure, and this raises the possibility that in the future you'd have basically some content neutral but pretextual rationale offered, and then there's a content based rationale, which is the real reason without which nothing would have happened, and then the court might kind of focus too much on this
Hmm.
pretextual content neutral rationale and either be deluded into thinking or deliberately pretend that it
Hmm.
would have been enacted but for this. But at the same
Yeah,
time,
true.
you know, you're right that part of the concern was mind control, but a part of the concern was spying. And there's certainly nothing implausible about thinking that American government officials and American legislators are worried about Chinese spying. We should all be worried about Chinese spying because the Chinese are particularly malign, although I do think that the Chinese government is a bad government, but of course our adversaries are trying to spy on us. We're trying to spy on them. Uh,
Hmm.
so so it makes perfect sense that indeed as the content neutral rationale was at the very least a very large part of the
Yeah.
debate.
All right. Two other very quick comments. One was that some people have, if listeners have forgotten about the TikTok case, it might be because TikTok is still on everyone's phones that wants it. This is a law that has been found to be constitutional, but that the Trump administration has decided not to enforce. That bothers some people. It doesn't bother me that much, maybe partly because I thought it was a bad law in the first place, but also I think the same can be said of the criminal that the criminal status of marijuana and whatnot. So I just don't think that the non-enforced anyway. I don't think it's that outrageous. The other thing is, I wanted to point out that this is a case that this is one of two cases we're going to talk about that decided that a law passed intermediate scrutiny. So, it's for those like me who want to understand the First Amendment as something that provides solid protection but not insurmountable protection when the rationale and the means are good enough. I think this case should give you some comfort.
That's right, and the important thing is it is precisely the court's conclusion that the law was essentially content neutral, at least should be treated as content neutral. The justified applications of
Yeah,
intermediate
exactly.
scrutiny that are content-based would be strict scrutiny, which is much more demanding. And for a long time, the court has recognized that when it comes to content neutral restrictions, the government does have more authority. So it can set up, say, noise restrictions or or it can't restrict demonstrations because of their message, but it can restrict demonstrations because they block traffic.
Right.
So yes, you're quite right. As a content neutral law, it was judged in intermediate scrutiny and was upheld as some, although not all, content neutral laws the court has considered. So now let's turn to another case. This is one that the that was argued this last year, hasn't yet been decided, but conventional wisdom is the writing is on the wall, and it says the statute is going to be held unconstitutional. So the case is Child v. Salazar, and it has to do with a Colorado law that limits, that essentially bans um, uh, so-called conversion therapy. Imprecise label, but that's the one people may have heard, with regard to sexual orientation or gender identity for minors. So if a minor comes to a psychiatrist, even with the minor's full enthusiasm and with the parents' supports, um, and says, I am attracted to the same sex. I don't want that to be the case for a variety of reasons, maybe religious, maybe others. Can you kind of help me lose that attraction or at least gain attraction to the opposite sex? That would be sexual orientation conversion therapy or gender identity conversion therapy. I feel that my gender identity doesn't match my anatomical sex or my chromosomal sex, but I would like it to. Again, maybe for religious reasons, maybe just because I think my life would be easier if I felt that way. Maybe I'd be open to gender reassignment surgery or whatever else, but that's a big deal. If I could avoid that by just coming to terms with my anatomical or chromosomal sex, that would be good. So under Colorado law, that's not allowed. The theory being that that's bad for the patient, and that's essentially a form of malpractice, and we can stop that from happening. At the same time, this is a speech restriction. Um, because the law bans, among other things, talk therapy, just talking to the patient. If the law banned pharmaceutical therapy or electric shock therapy or whatever, there'd be no First Amendment problem. There's no First Amendment right to electric shock or First Amendment right to take certain pharmaceuticals. But there is a First Amendment right to hear and First Amendment right to speak, and the law covers that as well. And it looks like the majority of the court says that is an impermissible speech restriction. Now, literally, of course, it is a restriction on speech, and the state of Colorado argues, no, it's a restriction on conduct, the conduct being psychotherapy. I don't think that's right. I've actually written pretty extensively about that. You can't strip speech of protection by just relabeling it conduct. And the court has
Yeah,
said that on many
these
occasions.
are not this is not spell casting.
Exactly, exactly. Uh, what's what I think what the real issue here? Well, I think the real issue is that uh, traditionally, we have treated professional client speech somewhat different from other speech. So let's just take a few examples. One of them is that this law actually involves two speech restrictions. One is a restriction on licensed therapists, but the other is a restriction on everybody, right? That you can't provide any kind of therapy to anybody, adult or minor, with some exceptions, if you're not licensed, right? It's a licensed profession, just like law is a licensed profession. We can't give legal advice on the law in a particular state to a particular client without having a license. That's a speech restriction. Outside the professional client speech context, that would be a so-called prior restraint, the hardest speech restriction to uphold, yet those are pretty routine. There have been challenges to them, but I don't think the court is prepared to say, nope, all licensing for the speaking professions is unconstitutional. Likewise, malpractice law. Generally, if I write something on my blog, I'm speaking to the public at large. I can't be sued on the grounds that I was negligent in what I was saying, even if I screw up some legal analysis. But if I give legal advice to a client, then I can be sued for malpractice. Likewise, of course, with psychotherapists. And it doesn't even require a lawsuit. Let's say that a psychotherapist offers clearly incompetent treatment to a patient, but thankfully no harm happens, maybe because the patient realizes that this is incompetent. Or let's say a doctor gives a patient advice, don't take any medicines for your cancer, just pray it away, let's say, or something like that. In his capacity as a doctor, that's his medical advice. Then that may very well be something that even if the patient doesn't follow it, so there's no harm and therefore no malpractice, maybe the doctor could be disciplined by the medical board, maybe lose his license. So there got to be some differences in the way that professional client speech is treated. But I think the court's view is that professional client speech is still generally protected. And one interesting question is, what will it say, if anything, about those differences? It may actually avoid all of these things because one thing you might say is all the examples I gave are basically viewpoint neutral rules. Nobody can practice medicine or psychotherapy or law without going through a certain licensing process. Anybody who negligently causes harm to a patient or a client can be sued for malpractice or can be disciplined. But here you have the legislature saying expression of particular viewpoints, or essentially saying to somebody with their permission, with their in fact their eagerness, oh, here is what you might do to change your sexual orientation, is just categorically forbidden. And that particular viewpoint and not others that are prohibited. So maybe that's one way the court will deal with it. Another possibility is tradition. The court has been quite interested in looking at history and tradition recently in free speech, as in other areas of the law. So they may say, look, there's a pretty long-standing tradition of licensing requirements of malpractice law, but these kinds of targeted prohibitions on certain kinds of professional speech don't have such a tradition, and therefore should be held unconstitutional. But to me, the most interesting question isn't whether the court will strike down this law. Looks like it will, but whether it will
How?
cast doubt on the other, much more familiar kinds of restrictions on professional client speech.
Yeah, I mean, I think another option. So what I don't love about the idea of looking at the legislation and saying, "Oh, this is not viewpoint neutral," is that you could say that as applied, malpractice lawsuits are also not viewpoint
Maybe
neutral,
so.
right? So a doctor's advice to I don't know, drink blink. A doctor's bad advice is bad because it is out of compliance with the standard viewpoint of the profession. And um, you could say, well, maybe what the court, maybe what the court will do is look for like controversial viewpoints. I think one
Mm,
way to do it, though, is to
yeah,
actually embrace what the tort system, the tradition of the tort system in malpractice cases has said, okay, when we're asking what the customary practice of the profession is, um, there will be times when there's not just one standard. There will be times where reasonable members of the profession actually disagree and make different choices, and there's not enough. There's not enough information, not enough solid evidence to have formed a strict single rule. And so the sexual orientations change efforts, especially with respect to trans orientation change, there's just hasn't been enough time, and therapists disagree. Like, as a matter of description, therapists disagree about what the best practice is. So that's another way that they could kind of avoid. I think stick with tradition and keep a narrow opinion. Of course, I wouldn't mind, though, if they went after the big initial question you asked, whether it is appropriate to have licensing requirements for pure speech professional acts. Of course, it makes sense. I think a state can condition a medical license to the extent that it's required for writing prescriptions and performing surgery and whatnot. Everything that things that are related to conduct and to actual invasions into the body. But therapy is different. Many aspects of law are different. That's a lot of it is just giving sound advice, and it might make sense for the First Amendment to require something more like a certification rather than a licensing restriction. But anyway, that's probably not where the court's going to go. I agree with you there.
right. Although who knows? Who knows? Court
Yeah.
surprises people, and we, among other things, even if we know what the likely result is, we don't know whether it's want to write a long opinion or a short one, a broad or a narrow one.
Yeah. Yeah.
So
Yeah.
there's a Russian phrase, "Поживем, увидим." We'll live a little and we'll see. So
That's
that's
exactly the common law. That's great.
exactly right.
I also
All
did
right,
want
turning
to.
to you. I'm sorry.
Let me say one more thing. I think listeners who hear us and might not sort of follow the background science might think, well, this is really terrible, because all of the medical associations insist that there is a strong correlation between sexual orientation change therapy and depression, suicide, bad outcomes. And at least the last time I looked at this, which wasn't that long ago, these are just purely correlation studies for the most part, and they can't tell us much, because people who are suffering from, for example, their family abandoning them because they're gay or because they're trans, they're likely to already suffer more than the average person. And so just as you can't say much about the studies finding that women who get abortions are more likely to be depressed, that too has a omitted variable that explains it. I think this too, I think that the same sort of statistical problem is in these studies as well. So I really genuinely think that we don't know much about whether these practices are good or bad. Okay, sorry, let's go on to the next case.
And it's Free Speech Coalition versus Paxton, and it's all yours, or rather, the start of the discussion is
Yeah, the
all yours,
start.
Jane.
Although, as longtime listeners know, I'm a lot looser on details, and my memory is much poorer than yours. So I will just, so I'll do what I can. So Free Speech Coalition versus Paxton was the First Amendment challenge to the Texas law requiring age verification for websites where 1/3 of the content is basically porn. What in First Amendment lingo we'd say is obscenity with respect to minors. And so the question was whether an age verification, sort of process applied to websites could survive the relevant scrutiny. The Supreme Court, with Justice Thomas writing, which I think was assigned everyone, that it was probably going to survive scrutiny, because I think Justice Thomas would go even further than the rest of the court with respect to restrictions on children when it comes to speech. Justice Thomas said, "Look, this does first of all." When it comes to content that is obscene with respect to minors, the government does have a freer hand. And even though in other cases involving the internet and access to porn, there were reasons, for example, at the time of ACLU versus Reno, to be skeptical about laws that would impose some burdens on websites. This is a burden that is well tailored to the context. If you're running a porn site, it's appropriate to check the age of your audience, much the way, say, a convenience store would have to check the ID of somebody buying alcohol or tobacco. So please add your nuance, Eugene, and correct any misstatements I may have made.
Right. Well, I agree that's the general shape of the court's reasoning. Just to highlight a couple of things there. So first of all, the Supreme Court has already said that certain material that is protected for adults, that it's a not punishable obscenity, is still obscene as to minors.
Right.
It's just illegal to sell it to minors, at least when you know that that the recipient is a minor, or illegal to distribute it to minor. So this is an unusual situation in the First Amendment area, but not unheard of when it comes to constitutional law generally, where something is protected for adults, unprotected for minors. So the question then is, what kinds of restrictions that are aimed at shielding minors are permissible when they also burden adults? So here, part of the problem is that age verification would burden adults. It may be somewhat more expensive. It may also undermine the adult user's privacy interests, because they'd have to identify themselves. They may not want to identify themselves as someone who buys porn. Um, so, that's the question. So on the one hand, we know that the speech is protected for adults but unprotected for minors, and then the question is, what kinds of restrictions aimed at shielding minors are justifiable despite their burden on adults, and how should we evaluate that? And it turns out that this is an issue that comes up in other areas too, right? So Supreme Court has said that there's a Second Amendment right to acquire guns, but that minors, and the court has never said that as to minors, and everybody assumes that minors, at least, there's a debate about 18 to 20-year-olds, but under 18-year-olds don't have such a constitutional right. Presumably, gun sellers could be required, as in fact they are required, at least professional gun sellers are required, but any gun seller could be required to check the ID of the purchaser, or even the non-purchase transactions check to make sure the recipient isn't a minor. Would that interfere with people's privacy interests, perhaps, if they want to buy a gun privately? Yeah, but that's considered acceptable. Likewise, uh, adults have a right to marry, children don't have a right to marry. They may be required to identify themselves, to show an ID in order to marry. Now, that may be a different matter because marriage has long been understood as a matter of public record. But that's just an example. I'll mention one other thing that back before Dobbs, abortion was recognized as a right for adults, but not fully for minors. Minors' abortion, there could be quite substantial restrictions on abortions by minors. Um, I asked around among people who knew, like, how, how abortion clinics would deal with somebody who comes in and looks like maybe underage. What would the abortion clinic do in order to comply with those laws? And the response I got is yes, they would check the ID, and of course they would try very hard to keep all that information private. But just because adults have a right to access abortions doesn't mean that you couldn't have age checking. And of course, that traditionally had been the thing for bricks and mortar stores with regard to pornography. So the question was, does this apply? How does this apply in the age of the internet? Where on the one hand, pornography is more accessible than ever before for minors, but on the other hand, also concerns about privacy may be especially great because before, if you have to identify yourself to a clerk, you may worry there'll be gossip. The clerk will tell his buddies or whatever else. But here, there's a worry that that information will be either resold or stored somewhere. There's a hack, and then millions of porn users would be identified. So the Supreme Court strikes that down and, excuse me, strikes it down, upholds the law.
Hmm.
The Supreme Court rejects a First Amendment objection to the law. And what it says is, look, the law should be treated as if it were content neutral. Obviously, it's content based. It targets sexually themed material, but it is aimed at unprotected material for minors. To the extent it burdens adults, it's only in the course of enforcing this already recognized obscenity as to minors exception. And here's the interesting twist. The majority says, well, it's important to subject this not to strict scrutiny for content-based restrictions, but to the intermediate scrutiny, because strict scrutiny should be very, very strict in order to protect fully protected speech. That it should be fatal in fact, absent truly extraordinary circumstance. Whereas the dissent was saying, well, we should view this under strict scrutiny because it's the content-based restrictions that interferes with adults' ability to access material that's protected to them or for them. But at the same time, we acknowledge there may be a compelling interest in shielding minors that would justify upholding at least certain kinds of restrictions. So they say the dissent says we're more protective because we apply strict scrutiny more broadly. The majority says we're more protected because we apply strict scrutiny more deeply. That
Hmm.
we want it to be super, super hard to satisfy, as opposed to the dissent, which is willing to have some laws upheld under strict scrutiny. But in order for that to work, we have to essentially limit it to exclude situations like this one, where there's an attempt to police this existing First Amendment exception. So interesting conceptual matter, I think important practical matter, of course, as well. Obviously, pornography is both big business and just lots of people use it, presumably enjoy it. So this is actually pretty important practically. But there's also this interesting conceptual question at the heart of it.
But which of those do you think is better free speech policy? A less expansive coverage of strict scrutiny, but a higher standard that the government would then have to clear, or
Yeah, I'm inclined to say that, and I'm not sure how it should play out in this particular case, but
Mhm.
that we should be open to certain kinds of categorical exceptions to protection, rather than funneling more and more through strict scrutiny.
Scrutiny? Yeah.
And this is, in fact, what the court has
And
long said with regard to commercial advertising, that
yeah,
given that there are lots of restrictions in commercial advertising that we're going to uphold, if you apply the same test to commercial advertising as you do to other speech, that will just dilute it for other speech. So I do think that
right.
if there is a good reason to say that this is just categorically excluded from strict scrutiny for the following reasons. It's better
Yeah.
to do that than to say, well, strict scrutiny, sometimes we will uphold the law under, that test. In fact, not that rarely uphold a law that could then bleed over into upholding restrictions on speech that is fully protected, as opposed to
Right.
this,
And
which
and
is
and
sort of borderline.
and porn too was one of these categorical not it wasn't unprotected, but it was
Right.
an exception to the way that the usual rules apply.
Right.
So
Yes,
this
it
is
has been
in
in fact in
yeah,
various ways.
exactly right. Yeah.
So
Unlike violent speech, which
exactly.
you could imagine if we were just making if the court were to make all new decisions today, it might think that violent speech is kind of like porn, has similar social
Hmm.
issues, but in fact the customs and the past cases have gone the other way. So
Right.
right.
All right. So we've done the Supreme Court, and now we're going to turn to some things that that have
I
come
think
up.
the rest is Trump.
Well, the rest is Trump, except the last part, which is Trump adjacent. Uh, so
Don't
the
even know
Trump
which one is Trump
administration
adjacent, but we'll see.
has been doing various things that at least quite plausibly can be seen as affecting free speech that have not yet reached. So one of the first really high profile things had to do with the Trump administration's executive orders with regard to various law firms. Uh, there were law firms. The reason for the orders was the position that the law firms had taken in various legal actions before. Um, and the First Amendment protects not just the right to speak, but also right to petition the government for aggressive redress of grievances. The Supreme Court has said that includes a right to go to court to ask for certain remedies, and it includes either the petition clause or the free speech clause, the right of law firms and lawyers to represent clients in court. Uh, but the orders basically said because of the various positions that the firms have taken, we're going to do various things to them. We're going to deny their members certain security clearances. That's a somewhat separate issue, which is also being litigated, but I'm going to bracket it for now. But also, basically, we're going to not allow them access to certain government buildings. We're not going to allow them to participate in various matters related to government contracts. Uh, by the way, if all the government said is we're not going to hire them as our lawyers, the government might be able to do. But it was quite clear these orders went well beyond that and interfered with these firms' ability to represent other clients.
Mhm.
So the firms had to figure out what to do. Do they give in to the government's demands to change various policies and do various things, and uh, uh, or do they fight it? And some firms gave in to the demands, and I don't want to fault them for that. They are commercial institutions. They have responsibilities to their shareholders, to their employees, to their clients, and they may have thought, that's what we have to do. But other firms fought it, and really quite successfully. Uh, Part of the rationale that the courts have given, this point, it's trial courts. I don't believe any of these cases have yet reached the appellate level, although appeals are pending. Um, Part of the rationale that was given is that, at least with regard to criminal representation, interfering with these firms' ability to represent criminal defendants in federal courts and other federal proceedings, that burdens the rights of the defendants to have the client counsel of their choice. But courts have also said that this interferes with First Amendment rights as well. That the First Amendment prohibits government officials from relying on the threat of invoking legal sanctions and other means of coercion to achieve the suppression of disfavored speech. That includes these kinds of just exclusions of firms from various kinds of actions related to the government, and not just criminal prosecution of lawyers or civil liability. And that as a result, these orders were, at least in large measure, unconstitutional. I think that's right. I think it's good to see courts enforcing the law here, the First Amendment law here, and limiting the government's ability to retaliate against its ideological enemies in this respect. To be sure, the government has considerable ability to retaliate against ideological enemies, But obviously, not obviously, my view, obviously, it has to be limited
Mhm.
by the First Amendment, including with regard to actions such as this. One interesting fact is a case that is very often cited here is NRA v. Vulo, which was a case from a year plus ago now, which actually I was one of the lawyers for the NRA on, but was argued at the Supreme Court by David Cole, who was at the time the National Legal Director of the ACLU. So the ACLU represented the NRA at that stage. The challenge there was a blue government, the New York state government, that was trying to retaliate against the NRA, or at least the allegation is that was trying to retaliate against the NRA. There hasn't been a trial yet. This was on a motion to dismiss. The allegation is it was trying to retaliate against the NRA by pressuring financial intermediaries to stop doing business with it, and that interfered with the NRA's rights because even though it wasn't prosecuting the NRA, it was using this kind of coercive power over these intermediaries. And the Supreme Court said unanimously that's unconstitutional. And at the time, there were people who faulted, including two chapters of the ACLU, including the very important New York chapter, faulted the ACLU for representing the NRA on this. And in the retrospect, I think very sound move on the part of the ACLU. It set this unanimous precedent that is now being cited routinely in this case and in other cases. Excuse me, in these cases, the law firm cases, and in other cases, in order to defend First Amendment rights against a conservative administration, which is, of course, as it should be. First Amendment rules protect people regardless of their ideology, and that's why I think it's important to protect even people on the other side of the aisle from you, because that protection, if established, will end up helping your people as well.
Well, and Vulo, I think, and the importance of, yeah, will also wind up being related to the university issue that we're going to next.
Absolutely, absolutely. So, shall we turn to
Sure.
the university matters?
Yes. So another controversy that cropped up pretty early in Trump's second term here was his decision to use basically almost every sort of string and power he has to pull to try to change the university culture, to try to his words, I guess, make it less woke. Now, I think the first major action was taken against Harvard. Well, let's see, maybe there might have been an executive order of some sort before that, but the first direct interaction with a university was Harvard, where Harvard was probably the Trump administration's maybe best chance to leverage some of the non-speech conduct issues that relate to university practices. So, the Trump administration pointed out that Harvard may have been in violation of Title VI by failing to protect its Jewish students during a time when some of the student protests related to the war in Gaza led to various acts of abuse and intimidation against Jewish students at Harvard. So Harvard's own sort of internal, investigation did indeed find that it was out of compliance with its understanding of Title VI. The trouble, and so the Trump administration threatened to cut off Harvard's access not only to future grants, but even the grants that had already been awarded to Harvard, and wrote a letter trying to force Harvard to enter into a settlement and agree to do various things, including changing, not only changing how it addressed student demonstrations that might have an effect on Jews and other demographic groups, but a whole range of things that would change how the university is run, how it does admissions, how it does hiring, and then how it treats basically faculty and classes that teach controversial subjects, and so let's see. So Harvard University didn't agree to the settlement, and they filed a lawsuit. And the district court, so they had a few different claims. One is that cutting off funds that had already been awarded might have been a violation of a federal statute or anyways. But the more interesting questions for our purposes are the First Amendment questions. So Harvard claimed, first of all, that the attempt to the attempt to prevent Harvard from being able to access any research funding at all. We're talking about over $1 billion in research funding. Was a retaliation for things that had to do with speech, and it was not just limited to Title VI violations, but that, and indeed, Harvard had a lot of fodder to play with, a lot of statements by Donald Trump himself saying that, Harvard has been terrible and has done has taught a lot of woke concepts, and they had plenty of tweets for ammunition. They also claimed that, even putting aside a retaliation, the conditioning of these large research grants on certain conditions that had to do with sort of the viewpoint, the sort of political viewpoints of the researchers and the research ends, violated the unconstitutional conditions doctrine. And those arguments persuaded at least a district court. This too is a case where I don't. By the way, after this, the Trump administration also released a compact that it tried to impose on another set of pretty elite universities. I think all of the universities that were specifically targeted actually rejected the compact, but a few other universities signed on to the terms of the compact. But that compact too looked a little bit like the Harvard settlement letter. It was probably improved a bit. It was a bit less unconstitutional in terms of identifying specific specific viewpoints that can't be sort of embraced. But it too had some constitutional frailties. So far, I think that only the Harvard case has had an opinion. Eugene, is that right?
That's the one that I remember
Okay.
as to specifically the university challenges, although they're
Yeah.
to the challenges to the things that target universities. Although I'll
Yeah.
mention briefly, there's another case involving, or at least there are other cases involving targeting up grants.
Okay. Okay. Yeah. So I tried to look if any of the compact universities
Right. I don't know of
cases
any
have.
compact cases.
Yeah, and I think Columbia filed one, but that it doesn't have an opinion yet. But anyway,
Mhm.
but the district court agreed with Harvard that, for the most part, the exchange was a coercive and sort of unconstitutional use of federal funding in order to try to not only affect the research that's funded by the grant itself, but actually to spill out into the viewpoint and pure speech activities of the entire university.
Yes. So I think that that's right. That I do think that there are real constitutional problems with this, and the case that I wanted to mention is. At the same time that the administration was targeting particular universities, it was also cutting off grants that it saw as unduly linked to DEI or to sexual minority matters or something like that. And the Ninth Circuit just a couple of weeks ago basically concluded that indeed that kind of the terminations of grants on those grounds were indeed First Amendment violations. But in order to understand that, I think we need to step back a little bit and think, what are the government's powers with regard to the money that it awards? So on one hand, when the government decides to promote a particular program or particular message, it is surely entitled to pick and choose what viewpoints to promote. As was said in one famous case on the subject, Russ v. Sullivan. This was an example in that case, not the facts of the case, but it's, I think, a very vivid example. Um, the government can fund the National Endowment for Democracy without also funding a National Endowment for Communism or National Endowment for Fascism, right? Likewise, it could say, in fact, that is what it does through these endowments, we will give grants for promotion of democracy and not promotion of capitalism or fascism. Uh, if Likewise, if a democratic administration, either the federal or state level, says we want to promote uh, uh, um, research on how best to diminish global warming, and somebody says, "Well, I want use this money to explain why I don't think there is global warming, or why I think global warming on balance is concerns are overstated, and we don't need to do anything to diminish it." Or even I just want to spend these funds on what I think are much more urgent concerns than global warming. Well, the government could say, okay, fine, you're perfectly free to talk about it, but just we don't have to fund you for that because we want to fund a particular set of messages and not other set of messages. And you can just multiply that. You could have, you could have grants for recruiting videos for the military and they don't have to be spent on pacifist messages how people should not join the military because they shouldn't fight in a war, right? Um, so that's one low. On the other, on the other side, let's look at a really very broadly available program of funding. Let's say historically there were, for example, subsidies for newspapers and books. In some measure, there still are sent through the mail, or charitable tax exemption that's offered to 501c3 organizations. That's essentially a form of subsidy. Uh, or you could there are lots of other such examples. Historically, there was also there was a case, Spicer v. Randall, in the late 1950s, which was just a tax exemption from property tax in certain situations for people. Can the government say, well, don't want to give it to racists, or we don't want to give it to communists, or people who aren't willing to condemn communism, let's say? That was the issue in the 1950s in some measure. Or we will give a 501c3 exemption to various groups, but not ones that support a policy that's contrary to the administration's policy on Israel and settlements. That was the fact of a case called Koskin and DZ Street in the DC circuit some years ago. The answer is no. The government here is setting up this broad program aimed at promoting a diversity of private views. And it can't then impose viewpoint-based restrictions on that. There's a Supreme Court case, the leading case is Rosenberger versus Rector, where University of Virginia said it would fund all these student newspapers, but not religious ones. And the court said that's viewpoint discrimination. It's impermissible because you're targeting religious viewpoints for special exclusion that other viewpoints are not subject to. And it's not in the context of a specific message you want to send. The whole point of the program is to promote a wide range of messages. You can't then exclude certain messages in a viewpoint-based way. So those are the ends of the spectrum. And then the question is where you draw the lines in the middle. And the courts, I think, are settling on the view that the government can't just say here, with regard to a wide range of benefits, whether it's student loan funds or even just grants in a wide range of issues, we're going to exclude a particular viewpoints from them, or we're going to exclude universities that express those viewpoints, or we're going to exclude universities unless they try to suppress those viewpoints. That courts are increasingly saying, and I think there's a lot of precedent for this, that is unconstitutional viewpoint discrimination. So we've got to agree, I think, that the government does have the power to discriminate based on viewpoint when it's selecting the funding of particular messages that it wants to promote. But a lot of university funding isn't that. A lot of university
Right.
funding is precisely we want to fund students, we want to fund institutions to promote a diversity of views. And once you do that, you can't then say, but not these particulars.
But not these. And let me correct myself too. I mean, I do think that the compact did was a bit more careful than the original Harvard letter,
Right.
but it did have some language that I think would
Absolutely.
violate this principle. So reading now from the compact, not the Harvard not the Harvard letter. The compact required signatories to commit themselves to transforming or abolishing institutional units that purposefully punish, belittle, or even spark violence against conservative ideas. Now, I actually don't have a problem with punish or spark violence. I think conditioning funding on making sure that the school doesn't punish or instigate violence against conservatives is well, I don't, viewpoint neutral to be sure, but no, maybe not. In any case, the thing that really bothers me is belittle, right? That using
Right.
funding
Absolutely.
to prohibit university units from belittling conservative ideas is basically creating a protection for conservative ideas, even those that don't deserve to be protected, right? Even those that
Mm.
might be based on, built from false premises. So the compact too has some
Yes.
problems.
Yes, absolutely. All right. So we're going to turn to the third action of the Trump administration. Maybe one of the questions is how much did all this caused by the Trump administration? But it certainly involves at least the FCC chair, so the chair of the Federal Communications Commission, and possibly other facets of the Trump administration as well. And that has to do with the Jimmy Kimmel controversy. So tell us about that, Jay.
Yeah, well, probably everyone remembers this goodie. So shortly after uh, Charlie Kirk was murdered, uh, there was, the facts were sort of slowly coming out about the nature of the killer. And there was I'd say some misstatements made in various settings, but one of them was that Jimmy Kimmel went on his show one night and said that basically that the Republicans or the conservatives are trying to pretend like the killer of Charlie Kirk was anyone other than someone from their side or something like that. And already by that point, I think the Utah Police Department had released enough information to at least shed some serious doubt that the shooter was a conservative or a groyper, or someone from the far right. So Jimmy Kimmel's statement may have been inaccurate and maybe also not based on the best available evidence at the time. That would, but of course, the news gets a lot of things wrong a lot of times, and Jimmy Kimmel isn't exactly the news. But it was upsetting enough to a large, portion of the Trump administration's base, I guess, that the FCC chair made public comments, I believe on Fox News. But in any case, he said that the FCC is going to consider applying an FCC rule on news distortion to penalize ABC for basically for distributing this content. And we had a whole episode on this with Ashutosh Bhagwat, so listeners can go back and review that if they want. But this is an FCC rule that hasn't been enforced, or at least not for a long time, and almost certainly would violate the First Amendment if it were enforced and then challenged. Or at least in this context, certainly, I think we all agreed it would. But this public threat, though, was timed. I mean, it happened to come out at the same time that some of the local owners of the local affiliate stations cut out the Jimmy Kimmel show from their broadcasts of ABC. Not clear how much that had to do with the FCC chair's statements or not, but I think the point was made. I think people were rightly outraged that the FCC would try to threaten a media company like this and rely on the special context of broadcast, which, yes, it does have some special First Amendment exceptions, or a little bit more leeway given the need for the federal government to be involved in licensing and spectrum management. But I think even the cases we have, Turner Broadcasting, and et cetera, would really make the FCC's action, the FCC chair's threat here. None of those cases would support what the FCC chair was threatening to do.
Yeah, so I think that that's absolutely right. It's hard to know exactly why it is that the suspension of Kimmel happened and why that was then lifted. But there is suspicion that there was some degree of government pressure, although obviously not enough to get Kimmel canceled, and that at the very least it sounds like there was an attempt at government pressure. So even if there was no First
Mhm.
Amendment violation, I think what we have here is returning to that NRA v. Volokh case I mentioned. It's a classic example of government pressure aimed at intermediaries in order to try to suppress speech that I think it would be unconstitutional if it were the cause of speech suppression.
Yeah.
I was glad to see there was a lot of pushback to it, including from some people, at least on the right, including, for example, Senator Ted Cruz, who
Right.
sharply condemned the FCC chairman's statement. So I think that's um, uh, my hope is that the message from that incident is going to be that the government shouldn't be trying to to impose such pressure, and if it does, that there will be pushback because ultimately the main constraints on a lot of this stuff are political, much more so than direct and judicial.
Yeah,
Um,
the trouble is, in addition to when the FCC chair says what he said, I think it's very easy to see the threat for what it is. In the wake of the case Murthy, the Murthy case, that was a 2024 case, but still fairly recent, where the Supreme Court found that, well, I don't know, it was a standing issue, but basically, that it left some questions open about how much sort of jawboning, or what courts will do with something that's more like soft pressure.
right,
That I think the Jimmy Kimmel episode reminded me of that. So that's sort of that's a nice mirror image where we had a Democratic president using. Well, I thought that the most threatening thing was when when his spokesperson said, we don't like that the social media companies aren't taking down this content that's dangerous for public health. And by the way, we're looking into antitrust options, right? So that was a at least a sort of veiled threat that there is a law here. We might brush it off and we might use it to our advantage. And antitrust has come up again with respect to the Bari Weiss controversy. Her decision to pull a news story related to the deportation, the foreign facilities that we're deporting immigrants to right now. But there's speculation that she made that decision under pressure because of some because of a merger or an acquisition, doesn't want to get caught up with antitrust problems. And so, I think I've seen enough examples now where I think antitrust is one of is just as the FCC rules provide one lever for the president especially to meddle with media. I think antitrust is another one. We might see more. This is something we might look out for in the next couple of years.
right, right. So just stepping back, the First Amendment protects against more than just criminal prosecutions for speech, against more than just civil liability for speech. It does protect against at least certain kinds of subtler governmental coercion, but in the nature of things, it's just a lot harder to get at some of that coercion. Some of it is subtle enough that you can't prove it, even though everybody in the regulated industry
So,
feels in some measure pressured, in some measure coerced.
yeah.
So we'd like there to be, I think, strong First Amendment protections against that kind of subtle coercion, and there is doctrine that supports that, but some level, the government can indeed get away with certain things, again, unless it sees political pushback. That's why political support for free speech is as important as judicial support, just also not that easy to find. So let's close now with another Charlie Kirk related matter.
Hmm.
So following the Kirk murder, there were a bunch of incidents in which people were fired or otherwise disciplined by their employers for what was seen as wrong, offensive, insensitive, evil reactions to the murders. A few of the reactions we saw were people who actually seemed to endorse the murder. More of them were people said, he got what he deserved. Not that murder is good, but I'm not going to cry about this. Or it's too bad that he was murdered, but he was a bad guy. That is something that might violate certain norms about not speaking ill of the recently dead, and also norms about wanting to really very sharply condemn in an unreserved way political murder, which is just political murder is poison to any country, especially a democracy. And I think we shouldn't be saying, well, it's bad, but I think it should be basically just it's bad. Nonetheless, that speech is protected by the First Amendment, generally speaking, in the sense that nobody can be criminally prosecuted for it. Question is, can they be fired for it? And that's been litigated a bit and probably will be litigated a bit more. So when the government is firing an employee for the employee's speech on a matter of public concern, and speech in his private capacity, not speech as part of his job, but speech just in a tweet, let's say, or even a conversation
Hmm.
over lunch with friends. There are First Amendment constraints on the government. In fact, there was a case, Rankin v. McPherson, from the 1980s, which also involved speech about an assassination that attempted assassination after President Reagan was wounded by an assassin. Somebody was working in a clerical capacity for a law enforcement office in Texas. Said to a coworker who was also her boyfriend, "I wish that if they shoot at him again, they'll kill him." And she was fired for that. And the Supreme Court said, nope, this is speech on a matter of public concern. It's presumptively protected. But it's only a presumption. And that presumption can be rebutted if the government can show that the speech is disruptive enough to employ,
Hmm.
uh, disruptive enough to function as an employer. Note that's very different from the government acting as sovereign. You can't just throw
You're right.
someone in jail because a speech disrupted some government employment because he was picketing outside the office. You can't sue him for it, but you can fire him for it. And one of the things the court said in that case, Rankin v. McPherson, is it said, look, this was never really publicized. This was not a statement made to the public. It was just a conversation between two coworkers that happened to be overheard by a coworker. There was no real sign of disruption. But some of these public statements do yield disruption. So to the extent there have been cases on the subject, and of course it's just been a few months, so there have been relatively few decisions, courts do indeed try to apply that test. And sometimes they say, yes, this speech was sufficiently disruptive. Look at all of the condemnation of it. Look at all of the kind of public reaction that the employer had to field. The employer had good reason to think this would undermine the employer's credibility with the public, and therefore firing is permissible. And in other cases, they say, well, there really wasn't much public reaction. To the extent that it was, it's just people saying we don't like it, but that by itself isn't necessarily disruptive. And if you have to respond to some emails, you have to respond to some emails.
Hmm.
Um, so the consequence is that what we're seeing is that under this test, you have what would otherwise, in other areas of First Amendment law, be rejected as a so-called heckler's veto. So generally speaking, you can't suppress a speaker because a lot of people are upset by him, even if they threaten to attack him, even if the goal of the police is just to preserve the peace. They have to arrest the attackers and not the speaker. And
Suppress
if
the
people are
speech. Yeah.
just saying, I'm outraged, well, the answer is okay,
Okay,
they're
you're outraged.
outraged, but that doesn't mean the speaker can be punished. But when it comes to government employment, heckler's veto is alive and well. More broadly, it's this weird situation where the First Amendment protects speech until it gets too controversial, protects speech that
Yeah.
people basically don't much dislike. And then the question is, why was the person fired? So there is a zone of things where the employer is upset, but the public really isn't. And the coworkers really aren't. Maybe just a manager who's angry for ideological reasons. Or maybe they're too worried about possible future disruption, but there's really no basis to think that. So in those situations where the employer is upset, but really nobody else much is, well, then the speech is protected. But if enough people are upset by it, if it's sufficiently controversial, then it's not protected. A strange situation.
Well,
Although at the same time, the employer could say, "Look, we are hiring you in
yeah.
order to, let's say, maintain good relations with the public. We're hiring you to provide benefit for our job. And now, in the aggregate, you're a net loser for us. You're doing some of your work, but you're alienating enough of our clients, some of whom may be paying customers for whom when we're competing with others, with private entities for. Or in
Hmm.
any
Yeah.
event, you're
Yeah.
alienating clients, and you're just not doing your job as a result.
Yeah.
So
I was
that's
going to
the
make the
difficult
same.
thing here.
I was going to make the same point that an employer is, sort of by definition, trying to get some other thing accomplished, some other job
Right.
done, and so there's a way in which you can understand the First Amendment in the employer-employee context as being kind of a subsidy. Like you get your job, even though in the background employment context, especially in states that have that have what is it called, employment by will or
Employment at will, yeah.
at will. Um, if in other states you can be fired for the minor inconvenience to the employer, why should we put the public's money in greater? Why should we demand that the public pay for you to have employment in this
Right, right.
particular position?
Well, so yes, that's right. One interesting twist, by the way, is what happens if the employer is a public university? Some courts have said, well, because universities are supposed to be places where controversy is seen as valuable and not harmful. Well, there we provide more protection for speech by professors or by graduate students, perhaps who are working for the university and the like. And we're not going to accept a heckler's veto. And other courts say, well, no, and the university is still an employer, and again, it's an employer that's competing with others, with private universities, and also it's an employer that may be seeking donations. Seeking public support. So the fact that you're a public university professor doesn't give you much extra benefit. So here's one last twist that I want to add here. So we think of free speech. Sometimes we say it interchangeably, using the term interchangeably with First Amendment. But of course, First Amendment protects speech against the government. What about protections against private entities? Well, the First Amendment does not protect by its own terms. It only applies to Congress. So that's the federal government. 14th Amendment applies that to state and local governments. By its terms, it does not apply to private entities. But many states have statutes that do protect private employees from retaliation for certain kinds of political activity. Pretty much all states, for example, prohibit employers from firing employees based on how they voted. So they just say you voted for Trump or for Biden or for a communist candidate or some extremist right-wing candidate, you can't be fired for that. But other states, in fact, to one degree or another, about half the states um, also cover other kinds of political activity. California, for example, specifically makes it a crime for private employers to fire employees for their political activity. And courts have read political activity quite broadly to include advocacy of not just a candidate, but also a cause, a political ideology.
Hmm.
Now, it's an interesting question, is saying, yeah, I wish that, or I'm glad that Charlie Kirk is dead. Is that political activity? It's not actually advocacy of a cause, although it is, I suppose,
It implies,
advocacy of rejecting Charlie Kirk's
yeah,
cause.
yeah.
But let's take another example. Colorado has a specific statute that says that employer may not fire employees due to that employee's lawful activity off the premises of the employer during non-working hours, with a few exceptions. And speech is a lawful activity. So if you tweet something out, not from the employer's premises during non-working hours, that law seems to pretty categorically protect you. I don't know of any cases where these laws have been used with regard to these private firings. I think they're not present in all states. In some states, they're quite narrow. So I think a lot of employment lawyers don't even know they're there. Sometimes they don't provide very generous remedies. But that is also an interesting question, and also interesting for employers who want to comply with the law. Even if they're not sued, they can say, look, I expect my employees to comply with the law. Or let's say I'm a school and I teach my students to comply with the law. We ought to comply with the law too. It looks like certain kinds of those firings might in fact be illegal under these laws. And some of these laws provide deeper protection than the First Amendment test as to government employment, because there isn't this so-called Pickering balance where controversial speech ends up being excluded if it's controversial enough. For a lot of these laws provide very categorical protection. It'll be interesting to see if there's more litigation on that. So it's a long episode we've had because it's been a long year, long First Amendment year. We've covered a good many quite different kinds of free speech controversies, and I hope our listeners have found them interesting. Jane, any parting words?
Not really. I mean, I'm in addition to some of the follow up to the items we talked about in this episode. I think we're gonna wind up talking more about addictive design. I know we already had one episode on it, but
Absolutely.
there's just so many cases related to that, and a lot of different slight variations in the state rules that are sort of emerging and being challenged. So I think we're going to talk about that. Is there anything else you think you expect that we're going to wind up tackling this coming year?
Well, I do think a lot of these cases are not done. There's going to be a
Right.
lot more on the administration and universities.
Yep.
We'll probably have at least one episode on administration and law firms, just because at some point, presumably, the appeal to the DC Circuit will be decided by the DC Circuit. Right now, it's actually, I checked the docket, it's moving pretty slowly. Maybe the administration lost great enthusiasm for it so far. Like Likewise, the Charles D. Salazar professional client speech case
Mhm.
will be
Yeah,
decided. So it'll
decided.
be interesting to see. My one
Oh, and the
prediction is I'm sure
immigration
we'll. Pardon?
and the visas and free speech. I think we're going
Oh,
to have
yes,
more on that
absolutely.
too. Yeah. So
Absolutely. Whether people could be deported,
yeah.
um, legal aliens, people who even maybe
Yes.
have lawful permanent resident status or are here on student visas, whether they can be deported for speech that would be constitutionally protected,
Yeah.
if said by a citizen. So the one thing I think I can confidently predict is we're going to have a fun free speech year. Not necessarily a good free speech year, not necessarily a bad free speech year, but we'll certainly have lots of things to talk about. And Jane, will be a great pleasure as always to talk about them with you, and a great pleasure to have people tune in. Do people still say tune in? Remember when you actually
Yeah. The
tune the
dial.
radio? Tune in next week or in a couple of weeks. Same bat time, if you remember that same bat channel.
This podcast is a production of the Hoover Institution, where we generate and promote ideas advancing freedom. For more information about our work, to hear more of our podcasts, or view our video content, please visit hoover.org.